Good afternoon, everyone. I'm Nalini Vadapalli. It's such a pleasure for me to be able to share a few opening remarks as we begin the training on the prevention of workplace harassment and violence. I wanted to start by being very thankful for all of our presenters. It's a team that came together as part of an Access to Justice project that is funded by the Government of Canada. And it's been almost a year putting this training together, starting with a community consultation. So I want to acknowledge all of the communities that took part in the preliminary research to make sure that we identify the needs in the communities. So the training sessions and the activities to come after this training session will definitely meet the needs of our communities here in Nunavut. So I wanted to just take a few minutes to introduce you to Odessa Odell. Ms. Odell kindly agreed to accept this mandate for the Law Society of Nunavut, and we're delighted to have her as she brings her expertise in labor and employment, and she brings a broad scope of experience, in particular into human rights, workplace safety, insurance, and Ms. Odell has appeared before numerous courts and tribunals in both Ontario and Alberta. So we're very pleased to have her lead this training session. We will also welcome Priscilla Ferrazzi. Ms. Ferrazzi is a member of our Law Society since 2011. She's also an adjunct professor at the School of Public Health and adjunct professor at the Rehabilitation Medicine at the University of Alberta. She's currently a legal advisor at Queen's University. Also part of our team today will be Nadine Crossland. Ms. Crossland works with Lichen Consulting, which is based in Iqaluit, and she brings her unique expertise in monitoring and evaluation in the health and social services programming. All of our team have lived or have ties to Nunavut. And I would be remiss if I wouldn't acknowledge Romy Leclerc, who's a law student who spent school, and I'm thankful she's able to join us today from Honduras. And I know Gloria Song is also providing support to our team. Ms. Song is a Law Society member since 2013, and she's also our Access to Justice program coordinator. And a special thank you to Jason Chute from BLG, because without Jason, this is the first time we're delivering a virtual training. So I'm particularly thankful for the support that we're receiving from Ottawa. So without further ado, I wanted to make sure that all of our members, friends of our law societies, and I know we have law students from the law program joining us today, that you have had a moment to access all of the materials that are available on our website to make sure that you're able to follow the training today. So we will be taking a break after Ms. Odell's training session. And for those who would like to participate in the community visits that will follow the training sessions, and that will be over 3 years. We're very lucky to have received funding from the Government of Canada to visit the communities over 3 years. Then we will take a break, and then we'll finish off with the overview of the community program and the evaluation tool. So thank you everyone for joining us today. Again, thanks to BLG for allowing us to be able to deliver the virtual training today. And I know the session will be recorded and made available in due time. So thank you, everyone. And Odessa, the floor is yours.
Thank you, Nalini, and thank you, everyone. It's great to be here. Hopefully the sound is okay. It's a pleasure for me to be involved in this initiative, and a great pleasure to be assisting in the preparation of these materials, but also to deliver what I think is a very up-and-coming, if not already up-and-come area of the law. No question, workplace harassment and violence in the workplace are two topics that are front and center and have become a really big part of not only the workplace generally, society generally, and personally my practice has certainly grown in this particular area. So It's my pleasure to be here, and I thank Nalini and the Law Society of Nunavut for involving me and for involving BLG in what's a really wonderful initiative. I'm going to get started with just an overview of our plan for the training session today. So my philosophy in workplace harassment and violence training is very much to make it as practical as possible. You have wonderful legal framework materials in front of you, or that Nalini has provided in the form of the manual. And the presentation is very much tied to that. So the legal principles are all set forth, and we'll go through them, of course, in the training. But my intention is to make it as practical as we can and to facilitate some discussion, because we can all see the law plainly printed in black and white, but this is very much an area that evolves. It certainly has changed as workplaces have evolved. I can tell you in the last 7 months alone with the pandemic, it has changed even more drastically. And so ways to facilitate some interaction and some examples to get us thinking about how workplace harassment in particular can actually arise in the workplace and work through, what is sometimes a very gray area. So we're going to start with the framework, the legal framework, what the legal obligations are for employers in the workplace, and go through what some best practices are in the development of policies and procedures that employers should have in place to deal with workplace violence and harassment. We're going to touch briefly on accommodation during an investigation, and the two ties very much into the policy and procedure discussion that we're going to have. And then we're going to get into what I hope will be a very interactive, and we're going to do a test slide momentarily with an interactive tool that we've discovered through the pandemic to go through some scenarios. So that's sort of the plan, and then we'll have time for questions. We do have a Q&A in the WebEx software itself, so if you do have questions as you go, feel free to type them in. They can be directed to the panelists. Gloria Song is sitting next to me, so if there's anything that we can address as we go, we'll do that. If not, we'll take a look at that list at the end of the session and get through as many of them as we can. So if you can, I like to start with this slide because it really gives you a sense of where we are in terms of workplace harassment. And this is a little bit of an older study, but I find it really telling, and I find it gets people really thinking about just how big of an issue this has become. So a survey was done about a couple of years ago, and it was about reporting harassment in the workplace. And so the first bullet point with respect to the survey that was done indicates that about 60% of Canadian workers have reported having experienced harassment in the workplace over the course of their career. So from start to where they are today, 60% have reported having experienced harassment in some form. Of that number, about 42% reported having experienced harassment in the last 2 years. So one thing to really think about is we know for a fact that harassment is underreported. So to me, what stands out about these numbers is 60% have reported it. Can you imagine what the number is if you think about all of the unreported instances of harassment? So it just gives you a bit of a sense of just how much of an issue this can be in the workplace. And then moving in a little bit more of a focused area, about 30% reported having experienced sexual harassment in particular in the workplace over the course of their careers. And of that, 21% put that sexual harassment in the last 2 years. So it just goes to give you a sense of how big of an impact harassment does have in the workplace. So let's talk about what the framework is. So what's the legislative framework for workplace harassment? And in Nunavut, we have two pieces of legislation that sort of govern what the requirements are for employers. And the first is the Human Rights Act, and the second is the Nunavut Safety Act and the accompanying Occupational Health and Safety Regulation, or the OHSR, as I'll call it. So the first one, the Human Rights Act, is really applicable to the branch of harassment that is discriminatory in nature. And we'll get into all these definitions in a moment, but that's really where the Human Rights Act comes in. The bulk of the regulation comes through in the OHSR, and it contains provisions in terms of how violence and harassment have to be managed in the workplace. But at the end of the day, the fundamental principle that is the takeaway in terms of our legislative framework is that individuals have the right to a workplace that is free from harassment and also free from workplace violence. And the employers by way of this legislation, have a responsibility to put those mechanisms in place to prevent it, and to address harassment, to address corrective action if required. And all of that is encompassed in the legislation, which we'll go through momentarily. So let's, before we do that, get into some of the key definitions. So first step, we have two definitions of harassment that we deal with in Nunavut. The first is under the Human Rights Act. And the Human Rights Act defines harassment as vexatious comments or conduct that are known or ought to be known to be unwelcome. The OHSR defines workplace harassment as conduct or comment at the worksite that must constitute a threat to the health and safety of the worker. Now, in practice, generally speaking, harassment usually manifests itself in a form of repeated conduct or a pattern of behavior. But it's important to know that it is possible for one single serious incident to arise to the level of harassment under both the OHSR as well as the Human Rights Act. And from common law's perspective, and in most of the jurisdictions across the country, it's really an objective test, and that is whether or not the person knew or should reasonably have known that the conduct or comment was unwelcome or unsolicited. And that really is the root of when we're examining workplace harassment, what we're asking ourselves at the end of the day. One, is it harassment in the sense of whether the act itself would constitute harassment? And then secondly, whether the alleged harasser knew or should reasonably have known that that conduct would have amounted to harassment. So moving on into some examples. So whether the person knew or ought to have knew that the comment was unwelcome. I mean, there's some really obvious examples we can look at. So, for example, if the individual to whom a comment is directed immediately says, hey, I don't like that, please stop. That's an obvious example of seeing a situation where someone should know that the conduct is unwelcome. Another example that arises quite frequently is whether the worker in question is visibly offended, humiliated, or insulted. So, for example, maybe you have a witness who said, well, yes, when so-and-so heard that comment, they immediately, started crying, for example. So that's another example of where, it's very clear that the conduct is unwelcome. The trickier part is situations when it's whether the person should reasonably have known whether the conduct was unwelcome. And a good example of this, because I see it all the time, is if it's not in accordance with the worksite standards or policies. So many workplaces in the required harassment policies will list types of conduct. It's not an exhaustive list, but it will include examples. And if the individual, the worker who is alleged to engage in harassment, pretty much did something from that don't do list, that would fall under they should reasonably have known, because they should reasonably have knowledge and training with respect to the contents of the workplace policy. Another good example, and this has happened time again, which is why it's on the slide, is situations where the harasser may have previously engaged in similar conduct, but they've done it again, notwithstanding the fact that they were told that the conduct was not welcome. So we're going to do a bit of a test slide for the interactive portion. So the tool we're using is called Poll Everywhere. You'll see on the slide a question that's being asked, and it's which of the following may not be considered harassment, and there's 4 options to choose from. So you have 2 options to interact with the poll. You can either respond at pollev.com/BLG2266, or you can text BLG2266 to the number 37607. You'll be prompted when you join, and then you can vote A, B, C, or D, and the poll will actually start to move in a live fashion. So I'm just going to give a few minutes, because we're going to use this tool a lot in the practice scenarios. So I'll give people a few moments to figure it out on the phone and on the link to get their choices in. But like I said, I just wanted to give us an opportunity to test this out. So we've got some votes coming in for option B. We'll just give it a few more minutes to let you make your selections. I think it's a pretty clear answer. The ones down the line in the practical scenarios are perhaps a little less clear. So yes, I mean, absolutely, management decisions are typically not considered harassment. And we'll be using this tool shortly. If for one reason or another you're not able to access the Poll Everywhere option, you can type your response into the Q&A section on your screen through WebEx, and we'll be able to see the responses as panelists. Just make sure you select that you're sending the message to the panelists and we'll get your response. Okay, so moving on, let's get into some typical types of harassment. So some really common examples are things like bullying, jokes that are offensive in nature, verbal or written threats or forms of intimidation, insulting comments, gestures, or jokes. Isolation, to be honest, is one that's come up a lot recently in the remote working environment because it's easier to isolate. Sabotage is another one. Destruction or interference with another's property, a little less common these days as we're not really working in the office as much anymore. Ridicule and gossip is another one. Another interesting point, or an important point to mention, is that harassment would also include any kind of retaliation or reprisal against an individual for either bringing a complaint under harassment policy or participating in an investigation in any way. So that's a really important one. I raise it because oftentimes individuals who either are bringing forward a complaint or who are participating as a witness, for example, are very intimidated in that process. And it's important, and I raise this all of the time, that reprisal and retaliation for their participation is a form of harassment and would be prohibited. And that goes a long way because more often than not, it's a concern for individuals who are coming forward, especially if the alleged harasser may be somebody in management or a supervisor or something of that nature. Okay, so I'm going to get into some of the subsets of harassment, starting with discriminatory harassment. So all of the examples we just went through about the different types of harassment, and that's not an exhaustive list. It becomes discriminatory harassment if the conduct in question also refers to a personal characteristic that's protected by subsection 7.1 of the Human Rights Act. So if it has that element to it, then you may be looking at an instance where the harassment is discriminatory harassment. And of course, we know those protected characteristics include things like race, color, ancestry, disability, sexual orientation, gender identity, family status, just to pick a few from the list. So if the harassment includes any of those pieces, then it can become discriminatory harassment. Another thing to note with harassment generally, but also in particular discriminatory harassment, is that and this often blows people away when I'm giving training, and I do a lot of this in workplaces, so I give training to staff. And one of the things that they find very surprising is that it really doesn't matter if if the intent to either harass or discriminate is present. It's whether or not the act in and of itself constitutes harassment that matters. And so we see that a lot with jokes. That's a very common one where people don't intend to be offensive or don't intend to offend anybody. And that's the answer we get when we get them into a manager's office as well. I didn't mean to offend anybody. The reality is, though, is it could be harassment even if the intention's not there. And that often, especially from a workplace perspective, a lot of people find pretty surprising, and it sort of redirects their thinking on the topic just a little bit. So moving on to another subset of harassment, that would be sexual harassment. So it can be a form of discrimination. It's also generally recognized as a subset of harassment as well. And basically there's three components. So you've got unwelcome conduct. The conduct is of a sexual nature, and it detrimentally affects the work environment or leads to adverse work-related consequences. So those are sort of the three elements. So now you ask me, well, what does of a sexual nature mean? So it can cover a very broad range of things, as you probably could imagine. So physical conduct is an obvious one. Gestures or any kind of actions that seem to have sexual undertones or content could be there. Verbal conduct as well. And one that tends to surprise folks in the general public would be that because it's a type of discrimination as well, insults based on gender could absolutely be of a sexual nature, rendering something sexual harassment. And oftentimes with sexual harassment, you'll see that there's sort of two additional types that we don't often think about, but these certainly come up in the workplace. One is quid pro quo. So, basically saying, I would promote you if you do X, or the adverse, delivering reprisal. So I will not promote you if you don't do X. So quid pro quo is one that's unfortunately gotten a lot of airtime in recent years, and it certainly had a. I guess 2 or 3 years ago we were seeing a lot of this type of harassment complaint. Poison atmosphere is also one. Poison atmosphere usually arises in the context of repeated conduct. So if you have a workplace where jokes of a sexual nature are prevalent, everybody kind of does it, or a large group of people do it, or there's joking propositions in the workplace. I had a file once where that was very much the case, and it was very much a common thing in the culture, but that didn't make it not harassment. So that's a one that often comes up. The other thing I would say on poisoned atmosphere that's developed in recent years, and perhaps a lot even in recent months, is more than ever, individuals who work together are connected outside of the workplace. They have group chats, they text one another. When we were all working downtown, it wasn't uncommon to go to a pub on a Friday evening and to see, groups of people from a workplace who were convening together. So when these things start to happen outside of the workplace through group texts and whatnot, and I saw this a lot in the retail industry in particular, poison atmosphere, it starts to gray the line as to what is a work site. But the poison atmosphere type of sexual harassment, I found, really became prevalent in those types of instances, as opposed to necessarily, openly making comments in the workplace. So that's just a note, because I think that's really where we're going, especially with increased remote working. So we're going to take a real quick look at workplace violence as well. Very common in practice, because our occupational health and safety regulations require workplaces generally to address both. A lot of times in policies and procedures, we'll deal with them together to ensure consistency, to ensure that the policies and procedures, it's one thing to remember as opposed to two. Violence in the workplace is defined by the regulation to mean any attempted, threatened, or actual conduct of an individual that causes or is likely to cause injury. That can include, obviously, the physical contact, so hitting somebody or punching somebody. It can also include threats, which to me is often where we get into gray area. So if you invade somebody's personal space in a threatening manner, that can absolutely be violence in the workplace. And that's often, we'll get a lot of employees who will say, well, I didn't do anything, I just got in their face. Well, that in of itself can constitute workplace violence, or any kind of threat where it's reasonable that the individual felt that they could have been at harm or a risk of harm. The other thing that's very important with respect to workplace violence is it's not always worker to worker, and sometimes it develops in the context of personal issues or domestic disputes that find their way into the workplace. So domestic violence is a prime example. Perhaps there was an argument the day before, and one spouse shows up on the work site and is either threatening to cause harm or has attempted to cause harm. I actually had a file several years ago where it was a Monday morning, and I guess on the Friday there had been a bar fight, and one of the guys showed up at the workplace of the other on Monday morning, and ended up having an incident where police had to be called, etc. So it's not necessarily just between employees, and I think that's important to note. And we've already kind of hit on some of the examples, but you'll see they're at the bottom of your screen there. Okay, so we've kind of touched on what I would call the key definitions of what the different forms of harassment are and what workplace violence is. So now let's talk about what employer and worker, because it's in everybody has to participate in order to have a respectful workplace, but what the obligations are and what some of the best practices are. So with respect to the regulations and an employer's obligations to adhere to the health and safety regulations that are set out, is basically they're responsible at a high level for ensuring the health and safety of their workers. That's fundamentally what it is. And we all know, as we talked about at the outset of the presentation, you have a right to a harassment-free workplace. So the employer, what that means for them is that they have to take all reasonable steps to prevent and stop harassment in the workplace that's connected to the worker's employment. And so the gray area, as we kind of talked about with remote work, is what is connected to the work site or what is connected to the worker's employment could be actually very broad. So the obvious ones that we don't need to spend a lot of time on are things that happen on the work site during work hours. I mean, those are kind of the easier scenarios to manage. Incidents that occur between a worker and a non-worker, whether it's a partner or somebody from a personal context, but also a contractor, a supplier, a customer, or another visitor to the work site. That is an area that employers also have an obligation to ensure their workers are free from harassment or workplace violence in that context. And then even grayer areas, well, what happens at the holiday party, or what happens at a Habitat for Humanity build that was done with a bunch of workers. So what's connected to the workplace and what's connected to employment can actually be very gray. And I go back to the group text messages, because there's a certain point where that could very much be considered connected to the workplace, and that's a challenging situation to manage. So fundamentally, the employer has to, put measures in place to try and prevent harassment. If it happens, act swiftly to stop it, and then, deal with corrective measures if and when necessary. So I always like to raise, both in my training, but also in policies that I draft, the importance of supervisors and managers. And it's twofold. One, practically speaking, they are the eyes and ears of an employer in the workplace, and they're often the individuals that workers are having have a closer relationship with. They actually know them. They may not know somebody in an office, but they know their supervisor on site. But also in certain cases and in certain jurisdictions, it's important to know that if a supervisor or manager has knowledge of harassment and chose to do nothing about it, the employer could actually be liable for that. So it's very important to set out in policies, but in training and in practice, that supervisors and managers do have a very specific role to play in the prevention and the dealing and the addressing of workplace violence and harassment. So the best practice is very much to ensure that they are playing an active role in that process. They may have their own training sessions, and that they have a very good understanding of what the expectations are under the policies and procedures. So on the screen and in the manual, you'll see there's a number of things that we recommend that employers should ensure that supervisors and managers know how to do. So they understand what the policy is, how to find it. They report. That's so important that they report instances of harassment. And the other thing that I would flag there is that sometimes workers go to a supervisor to talk about a situation, but they don't want anybody else to know. And it's a really fine line. The supervisor wants to maintain confidentiality because the worker's asking them to, but the supervisor is also conscientious, because they had great training, that if they don't say anything, then the employer could be liable if things continued or got out of hand. So how do supervisors and managers deal with that situation? That should be part of the training, that they should have to say, because it is very possible that if a complaint comes forward, even if it's either put in and rescinded or put in an informal fashion, the employer may well have an obligation to investigate, regardless of whether or not the individual or the complainant wants to participate. And I think that's very important, because sometimes we get caught in a very awkward position where complainants don't really want to be participants, but as employers, we have obligations that are legislated for us to look into these events. So all those things are important to note, and supervisors and managers are key to that piece. So let's move on to the last big bucket, and that's worker obligations. So even though the legislation itself requires and provides workers with the right to employment free from harassment, fundamentally, it's everybody's responsibility. There's just no way it can work if there's not an accountability set out for everybody. And so workers should receive harassment training on the policy. They should be encouraged to be open and to report these instances. And one of the big pieces of that is they should be very well aware of the confidentiality that circles these kinds of complaint procedures and investigations, because otherwise that's usually the biggest hindrance to people coming forward. And so it's easier said than done. It starts at the top from a cultural perspective within an organization. But if an individual witnesses harassment, or if they are subject to harassment themselves, then the workplace itself, the employer's policies and procedures, and the training that's conducted on them should ideally give them a very easy path forward as to how they report it, and make it, very well known that confidentiality is to be upheld to the extent possible in order to, one, conduct the investigation. Obviously, there needs to be some disclosure to actually investigate, or to the extent required by law. So going back to the test poll we did, one of the questions, or one of the interesting pieces that often arises in harassment investigations is, what is harassment and what is a management decision? And so legally speaking, management decisions are not typically considered harassment. So, giving somebody a work assignment or performance reviews, for example, I couldn't tell you how many times I've had clients say, well, I have an allegation of harassment because, Sally didn't like the performance review. Typically the reasonable actions of management in a day-to-day setting are not considered harassment, but there are areas, and it does happen, where, there might be a discriminatory or an abusive element that's present, and that sort of takes it up a level. And I think we did put examples in the manual, but, if there was over-the-top sternness, or if the manager engaged in yelling when they gave it, say they gave a verbal warning, but they went over the top and started yelling, everyone in the whole place heard it, they used vulgar comments, or they used profanity, that's where you kind of seep out of the management decision and potentially into workplace harassment. So it can be a really fine line. It's important to think about that if you're being asked about whether or not a situation might be workplace harassment or not. And it's one, frankly, that we see very frequently, and they're some of the toughest to figure out, to be honest. So that's just a quick comment on management decisions. The right to refuse unsafe work is an interesting one. We've certainly seen a lot of it in the context of the pandemic, or in the context of very obvious, hazardous situations. In the context of harassment, it's a little grayer, and certainly the government of Nunavut has not explicitly identified it as a reason to refuse work in the legislation. Usually under Section 13.2 of the Safety Act, the right to refuse unsafe work is predicated on what they call an unusual danger. And that's something that doesn't normally exist in the work, or a danger in which a person who's usually engaged in that work wouldn't normally carry out. So under the legislation, a worker can refuse to do any work if they have reason to believe that there's an unusual danger, that carrying out the work is likely to cause an unusual danger to their health and safety of either themselves or somebody else. And most often, in the way the legislation is drafted under the Safety Act, really it seems to be centered towards, operating tools or machinery or anything of that nature that might cause an unusual danger. So it's not explicit. It's certainly a question, and it's a fair one, as to whether or not harassment would be considered unsafe work, or give you a right to refuse unsafe work. We'll talk about that a bit more in the context of investigations, because usually it comes down to removing somebody from a particular setting during an investigation, for example. But just to lay that nugget there for you to keep in mind, that I think it's still an evolving area. I don't think we've seen the last of it in Nunavut, but also in other provinces. It's not, it's a question that's come up before. But just know that in the context of the Safety Act, it's not an explicit issue that is recognized to trigger the right to refuse the work as being unsafe. So we're going to spend a little bit of time quickly on policies and procedures. So the OHSR mandates employers to develop and implement harassment policies in the workplace. The legislation itself actually lists, and most of it's on the screen there, it's in the manual as well, what has to be included in that policy. So you need to have your definitions in there. It has to have a policy statement about, the fact that workers are entitled to be free of harassment. They should outline things like how complaints are going to be addressed, what kinds of, who an employee is supposed to go to, and best practice would be, who do they go to with the complaint, and who do they go to if that person is the harasser or the alleged harasser. it should also include things in terms of best practices. It should also include things like, what does the investigation look like? Is it going to be conducted internal, or could it be conducted by an external third party? How confidentiality is going to be preserved in the context of these investigations. To me, that's a huge one. I know I touched on it earlier, but I can't emphasize enough. If you have a policy that talks about what confidentiality looks like, it makes it so much easier to tell a complainant or to tell a witness, this is how the complaint is being dealt with, and this is how your confidentiality is going to be preserved as much as possible. To me, I end up having to pull that out all the time, and I've had a couple where that confidentiality provision wasn't necessarily quite as robust as maybe we'd like, so it didn't really bring the comfort you would want it to. But it's something I would pay a lot of attention to if I was drafting a policy, or if I was looking to answer questions from somebody. It's certainly a best practice. So what's listed on the slide right now is basically what the law requires. The manual also includes some best practices that are beyond that. So a few others would include things like, consulting with your joint health and safety committee if you have one, or your health and safety representative if there is one, while you're developing the policy, to ensure that appropriate measures are taken. That might include providing a mechanism for workers to participate or to ask questions in the development of those policies, so that the employers have the ability to know what's top of mind for folks. And also, in my view, you have to look beyond the specific legal requirements into the type of workplace that you have. So, if it's a retail store, for example, if it's a corner store, well, and then everyone's in one place. But if it's, a business that has multiple offices, you have to figure out what works best for a particular context. Industry also matters. Retail versus construction versus, a legal setting, they all have an impact on what is going to give a workplace the best possible policy that they can have. And workers should know about it, and workers should be able to ask for it. Workers should know exactly where to find it, quite frankly, because they should be trained on it. But, making sure that if you have 5 working locations, that either they can access it on their intranet, or they can access a copy in the kitchen, for example, easily and quickly if they need to. So the workplace violence policy is, in practicality, very similar. And like I indicated, for the most part, employers who engage in this exercise, or who are mandated to engage in this exercise, will often deal with both workplace violence and harassment in one policy. And there's a whole bunch of reasons why that can make sense. Procedures for investigations, or for, who they go to, confidentiality, all that can overlap. So rather than having it duplicate and potentially causing confusion, they'll deal with it in one. So the OHSR mandates workplace violence policies in particular settings. So it's at work sites where violence has either occurred or could, reasonably be expected to occur. They actually require the implementation of a written policy. And the policy has to include a list of things, which is included on the screen. So very similar to workplace harassment, quite frankly. And just so you know, excuse me, I haven't talked this much in a while. The OHSR in particular has also set out various types of work sites where where violence could reasonably be expected to occur. So that includes things like healthcare services, pharmaceutical dispensing services, police services, security, financial, taxi and transit services. So the regulation has already identified specific types of work sites where they have deemed that violence could reasonably be expected to occur. So if it's important to know and to check the regulation to know whether or not the employer in question would fall into one of those. But even if they don't, if by an assessment that either violence has happened or could reasonably expect it to happen, then you may want to consider putting a policy in place. And you might as well do it part and parcel to your harassment policy, which is required anyway. Thank you. Okay. So as I said, if you want to just slow, sir. Yeah, thank you. So as I said, it's not unusual to have one for both. And it's easy to do that to make it compliant with the regulations in the OHSR. And basically what I typically like to do is take the regulation, take your list of things that you need, and just check the boxes to make sure it's all there, so that if there was ever a complaint, if the Ministry of Labor ever got involved, you would be able to show you check all the boxes in terms. And very importantly, because this area of law is changing, and you may, for federally regulated employers, for example, there's a whole bunch of changes coming to the Canada Labor Code in January around harassment. So it's a policy that should really be looked at regularly, both to ensure employers are still compliant, but also they should be reviewed regularly with employees. And best practice would be to have employees sign off on the policy review. It's not always feasible to do that, but you want to make sure your employees know where to find it and can access it easily. So we're going to really quickly run through, and all of this is in the manual, addressing violence and harassment in the workplace. So one of the things the OHSR requires is that employers assess the risks of workplace violence that may arise at a particular work site, and reassessment should happen as occurred. So if something major happens where, it would be reasonable to assume that the risks have changed, employers should be reassessing the risks of violence under the reg. Depending on the situation and depending on whether or not risks are identified, for workplace violence, employers also have to generally make sure that workers are informed of the nature and extent of the risk. And one of the gray areas, or one of the interesting areas where this can get a little challenging, is if it's a situation that, a personal situation may make its way into the workplace. So if there's a domestic or family situation that might expose or is likely to expose a worker to physical injury, and there's a likelihood or a reasonable likelihood that that injury could occur at the work site, according to the regulation, the employer has to take every reasonable precaution to protect the employee. And when you think about the fundamentals of the reg and the act in general, I mean, it makes sense because the employer has to take reasonable steps to protect the health and safety of workers. So with respect to workplace violence, there's two ways this can happen. I mean, if it's imminent, if it's an emergency, if it's already happening, obviously, employees should be very clearly told that, they have to call emergency services. They should, workers should also be told that, they shouldn't ignore threats. So people getting in somebody's face, if somebody witnesses that, they should report it. And then if there's an individual who's experienced either violence or threats of violence at home or in a personal situation where they think that might make its way into the workplace, they should also report that to a supervisor. So bringing a harassment complaint, so the starting point for everything, ultimately, if the legislation is being followed accordingly, it should all be in the policy. So the employer's policy should very clearly show how to go about bringing a complaint. Some policies have informal procedures as well as formal procedures. Some just have, one type of procedure. That's fine, as long as it's very clear what an employee is supposed to do. Usually it's, go to your direct supervisor, but there should be an alternative, whether that's, someone in human resources or, another manager, something like that, so that they know it's going to get triaged according to the policy to the right people to actually investigate the complaints. So receiving a complaint, so the individual who gets it, particularly supervisors and managers, who are usually the ones who will receive these, they should, one, never discourage a worker from bringing a complaint or pursuing their legal rights. And it is also the responsibility of the person receiving the complaints to ensure that it goes where it needs to go to be dealt with. So whether that's bringing it to human resources, or whether it's, making sure that it gets the right form filled out, whether that's helping somebody fill out a form. Some policies, require it to be in writing, some don't. Just to make sure that it gets input in the right place. And as I indicated, there can be penalties for that not happening, particularly if it's a manager or supervisor that received the complaint. Handling complaints, as we already sort of touched on, should very clearly address confidentiality. It should also include, if there are multiple procedures, what the difference is. So if it's informal, maybe it is, some policies will say, maybe there will be a mediated session between the complainant and the alleged harasser to try and work things out between them, or maybe the manager will talk to everybody. If it's a formal process, maybe it has to be in writing. or maybe some employers have policies where there's a threshold. So somebody puts in a complaint and the employer has a very objective criteria that they check off to see, okay, is this actually a harassment complaint or is this something else? But either way, it should be very clear. There should be no questions as to what is going to happen next. And if it is the formal procedure where we get into the investigation, the investigation process should also be very clearly set out in the procedure. So if you're going to go with an external individual, what the report looks like. I like to see policies that say, you know, at the end of it, the alleged harasser, the complainant, are going to get X. Usually not a full report, mostly never a full report, but they might get a summary of the findings, for example. The more comprehensive your policy is, the better off you are. But also you have to ensure that you follow the policy when you have it. So I flag that always because sometimes that's not the case. So as I indicated, most workplace violence and harassment policies will require that there be some sort of an investigation report. It's usually confidential. It should be confidential. Usually it includes things like the procedure taken by the investigator, a summary of the allegations, a summary of any witness statements or witness interviews that were conducted, as well as a summary of the alleged offender's responses. It may or may not include things like, you know, each individual witness will have the chance to review, you know, a summary of what they, you know, the evidence they provided to sign off on. You know, it can get really nitty gritty. It doesn't necessarily have to, but the general nuts and bolts is that you have summaries of all of the evidence set forth. And then any additional evidence. So if you review documents, they may not necessarily have to be appended to the investigation report, but they should be referenced, and the investigator should keep copies of everything just in case it's ever needed. You also want, like I indicated, a mechanism for the results and the process to be communicated to the complainant and the alleged offender. And that also includes things like updates throughout. So what can we tell them, what we can't tell them? Is the policy that they are going to get to see witness statements? Generally it's no, or even to know who the witnesses are. So my practice in investigations I run is typically if you know, I listen to the complainant first, I generate a list of witnesses. I usually interview all those witnesses first. I usually talk to the alleged offender last. And oftentimes I get asked, well, like, who else did you talk to? So I unless the policy would require me to, which most of the time it doesn't, my practice to ensure the confidentiality of witnesses would be to say, you know, I'm not going to tell you, you know, who I spoke with. If there are people you think I should speak to, give me a list, and then I'll either speak to them if I haven't already, or it's in my discretion to do that as the investigator. So you want a mechanism to address that, because you have to be prepared for the fact that both complainants and alleged harassers or alleged offenders are going to have a lot of questions. Again, communicating the results. So if you have an investigation where where the finding is very clear that there's been violence or harassment at the work site, the policy should also make it clear that the results of that, you know, could be discipline, and it could be discipline up to including termination. So some policies will include examples like you have on the screen in front of you. Others will just include sort of a general sort of a statement. But, you know, some of what's on the screen are pretty common examples. A very common one is, you know, counseling or some sort of training for the employee at fault. It may also be training for the entire workplace if it's deemed that, you know, while harassment occurred, it's not an isolated issue. And I actually do a lot of training type scenarios where I go into workplaces after a workplace investigation was done to sort of give refresher training to the entire staff. If there's been no violence or harassment in the workplace, this is where it can also get really tricky. There should be no consequences to the complainant, assuming that the complaint was made in good faith, and that's the assumption you should have unless you have reasons to think otherwise. If it's vexatious, or if it was done knowingly, you know, if they were knowingly lying when they brought forward a complaint, that in of itself could lead to discipline and corrective action, and that's important to flag. I usually, if I draft policies, it's included in there. It's important to know. And the other thing to think of, which we'll talk briefly in a second in terms of accommodation, is, you know, what's the ramification of the investigation in the work site? Because we make every effort to be as confidential as possible, but after it's all said and done, there's still a workplace that has to keep moving forward. And to what extent, if any, do we need to take action, or does the employer need to take action to ensure that people can still work together? So on that note, just a very quick piece on accommodation. So when a complaint's been made, the first thing an employer should consider when they get the allegation is, can the workplace remain as it is while the investigation is ongoing? Examples might be, can the complainant stay in the department? I've had instances where it's been senior leadership, and does that senior leadership have to be extracted for the duration of the investigation? Suspension with pay would be another one, not quite as common, but it depends. If it's an all-encompassing investigation that's, involves a lot of moving pieces, then that may be a thing. If it's a work site where there's a lot of shift work, changing up schedules is an easy fix to do temporarily. So those things should be considered right away. Is it safe for the worker to remain where they are for the time being? We always try and get investigations through the quickest as possible. Sometimes it takes longer than we'd like if it's a complicated situation, but we just want to make sure, because even though you have an investigation that's triggered your obligations as an employer to report and to investigate, the ongoing obligation that the employer still has, not just to the complainant, but also to witnesses, is to ensure that they have, they have a right to the health and safety of themselves in the workplace. So if that's at jeopardy for anybody at any time, then during the investigation, the employer should be keeping that in mind. It may also be necessary to look at accommodation after the investigation's over. So, can Johnny work with Susie now? Like, is that something that can even happen? Even if there was no harassment founded, is that something we can continue for the health and safety of those involved? So those are just things to consider, but they're absolutely something that an employer should turn their mind to right away. And I think seek legal advice, because it can be tricky in that regard. And if there's an employee or a worker who's either brought a complaint or who's been asked to be a witness, then they should have every right to bring that up as a concern, to say, well, do I have to work with Johnny while the complaint's being investigated? So that's just something to keep top of mind. Okay, so enough of me yakking excessively. We're going to start getting into some of the practical scenarios, and this is my favorite part of these presentations, and this will be interesting because it's virtual. So what I really want people to take away from today is that harassment, particularly, is really not always easy to identify. And I can tell you that I have gone into numerous investigations where I went in thinking one thing and came out thinking something else. That's why you have to investigate it. But it can be really tricky, and it can be really gray. And so the following practical scenarios are intended to get you thinking on, and I appreciate that they're contained, so you don't have all the facts necessarily that you would if you were looking at this as an investigator or as anybody else in a workplace, but what might make this harassment and what might make it not harassment. And so these exercises are really intended to get you thinking. So we're going to use the poll everywhere tool again. So I hopefully that's been figured out, and we'll do the first ones a few slower so that people can kind of get used to the function of the poll everywhere tool. And Romy Leclerc is going to help me work through some of these scenarios, and we're going to just tag team it. And the first batch are situations, and so I'm going to let Romy go through the first scenario, and then we'll go to the poll slide after. So go ahead, Romy.
Yes, and I'm so sorry for the music in the background. So the first situation. So we have Mario give Sylvia a negative performance rating. He expresses himself firmly but respectfully. He objectively lists everything Sylvia needs to improve to stay with the organization. Sylvia cries the rest of the day and is afraid to see Mario.
So if you want to take a vote as to whether or not Mario's actions constitute harassment, so your vote would be yes or no. I'll just give it a second because I know it's a. So we've got a no, got a couple no's. No. Awesome.
There's someone in the Q&A also saying no.
Okay, so someone in the Q&A is also saying no. So I don't see any yeses. So you're right. I mean, likely not. So we talked about the exercise of management rights, not being harassment as long as they're not carried out in an abusive fashion. So there's nothing in that scenario that Romy read out that make us think that Mario is being he wasn't being vulgar or yelling at Sylvia or anything of that nature. So chances are pretty good. Now think on that a little bit more in your head as to what may shift that situation to something that could be considered harassment. So maybe Mario and Sylvie have a history in terms of, maybe Mario has gotten into trouble previously, or maybe Sylvia's. Oh, someone says yes. So yeah, I mean, there are things that could happen in that scenario if we had more facts that could change the theory. But on its face, I would say more likely than not, as it's described, the answer would be no. So let's move on to the next scenario. So we've got Olivia. Olivia likes to monitor all of her colleague Julie's emails. So she's always surprising her in her office to watch what she's doing. She times Julie's lunch breaks. She watches what Julia eats for some reason and likes to laugh at her culinary choices. So let's consider Olivia. You can go ahead to the poll. So do Olivia's actions constitute harassment? What do you all think? Got some yeses. Absolutely. I mean, it's certainly not usual. I definitely don't know what most of my colleagues eat for lunch.
I know you eat sushi.
Yeah. Gloria knows I haven't eaten it yet, but I do have sushi for lunch. So I mean, it's certainly likely. I mean, I think all of us could say from a reasonableness perspective that Olivia's monitoring of Julie's activities is exaggerated for sure, and likely there's no basis for that. So yeah, to someone's point, a slippery slope. I totally agree. And so this would be one that if you were to hear that, as an employer, if this were to come to you, or even if, say Mario works next to Julie and Olivia, and Mario is witnessing all this, what would Mario think? And if Mario brought this to their employer to say, I think Olivia is harassing Julie. When you look at the type of examples or the type of questions that you could ask, I mean, this could, to me, I would, at least based on what the scenario is, lean towards a yes. Okay, Romy, you ready for the next one?
Yes, absolutely. So second, the third situation. Sabrina previously studied massage therapy. She loves using her talents on her colleague, Princess. She gives him several neck massages a day without asking him for permission. According to her, he's simply too shy to ask her, but as he does not reject her, it is clear that he enjoys it.
So what do we think about Sabrina? So let's pull up the poll. Lots of neck massages. That is. Yes, so we're seeing some yeses. Yes. Okay. Yeah, that's where my brain goes, is probably. The interesting thing with the facts we have in the scenario is that we know that Frances doesn't say anything, right? So when you circle back to the, it's ought is whether they knew or ought reasonably to know that the conduct is unwelcome. So just because Frances doesn't say he doesn't like the neck massages doesn't mean he likes them. It also doesn't mean that he doesn't like them. So again, very slippery slope. If you were investigating this, it would take a lot more questions, and it would frankly take, so you ideally she should have Frances's consent, and God forbid she hit a nerve the wrong way, and caused Frances an injury, which is a whole other kettle of fish. But I mean, giving him a some days absolutely, right? So massaging colleagues though would really not generally be considered a normal workplace practice. So I think we're probably heading to the yes, but in the scenario itself there's some interesting little tidbits that make you think, it's maybe not as obvious as we think it is, because again, we know Frances has never said yes or no either way. All right, so moving on. So Matt's always late. He's disciplined for his repeated tardiness, and he apologizes and said, I don't mean to be late, and no hard feelings, but disciplinary measures are imposed nonetheless. So, is this harassment? Are the disciplinaries themselves constitute harassment? What do people think? Okay. And if we may be just getting a lag from the.
I'm just trying it out at the same time, and it's giving me a
Okay.
weird personality cast result.
It's not going to the question.
Oh, it's not going to the question. Okay, so we're having difficulties
They
with
can
this.
post in the Q&A though.
Okay.
If you want to. If that's, oh wait, no, it's not.
I don't know what's happening with this one, so we're just gonna I'll just talk. So I mean, this is similar to one of the other scenarios we looked at where we're talking about management rights. So the key to this one that I think you need to look at. So yeah, maybe a bit heavy, but harassment not proffered. So that's fair. I think the key to flag on this particular scenario is even though Matt doesn't agree with the discipline, and this happens very often in workplaces, this is not an unusual situation where the employee doesn't agree with the discipline imposed, and so it becomes harassment. So even though Matt doesn't agree with the discipline, doesn't necessarily make it harassment. Now, we don't really know. All we know is he has a bit of a history, and all we know is that Matt says it's not his intention to be late, but maybe it's the bus. Maybe like we don't have those facts in the scenario. So just things to think about. But I agree, not really a clear case of harassment. All right, Romy. Next scenario.
Yes. The next situation, David and Kim do not get along. They constantly argue about everything, and since they work in the same department, they are in frequent contact.
Okay, so what do we think about this situation? Do we think this constitutes harassment?
Oh.
No. Okay.
Oh, sorry.
So this is interesting. I mean, it's a very short scenario, so we don't have a ton of facts. We don't know necessarily what they're getting on about when they have their conflict. So I mean, it could very well get into space where other people are, other people are concerned or other people are offended. But on its face, and we didn't really talk about this in the course of the substantive part of the presentation, but generally speaking, personality conflicts between two colleagues, as it seems to be the case with David and Kim, does not generally constitute harassment. It could get there, no doubt about it. And for example, if they're bickering back and forth or their conflict, gets to a point where it's intimidating or feels threatening to other people, or if the content itself is offensive, it could actually trigger somebody else to bring a harassment complaint or perhaps a workplace violence complaint. If they feel, unsafe because maybe David and Kim are yelling at each other constantly. So I'm inclined to agree no, because it seems to be a straight up personality conflict. But in thinking about where it could go if not addressed, then we could end up somewhere a little bit more serious. So moving on to the next situation. So we've got Antoine, who's new, and Justine, who knows Antoine from personal friends, doesn't like him. Doesn't like him at all. So she warns everybody not to be friends with him. She doesn't invite him to any of the socials. He's not on the group text. And she actually will turn her back on him and ignore him when he tries to intervene in conversations. So according to Justine, she just does not like him from a personal level, and she would prefer her colleagues to be loyal to her. So it's a bit high schoolish, as a situation. So do Justine's actions constitute harassment? What do people think? Yes. Yeah. Yeah, absolutely. So you've hit the nail on the head. Isolation. So as we talked about isolation, sabotage is another thing that comes to mind in this situation. She's infringing on his abilities to make, connections in the workplace, or to even come across as a credible professional, perhaps, by telling people she doesn't like him. But certainly things like isolation, discrediting somebody, it definitely fosters a poisonous work environment, and it's very much damaging to Antoine's reputation. So especially, I would say in this scenario, especially if this becomes repeated behavior, the pattern of behavior itself would likely make this harassment. If she just turned her back on him once or made one comment, there might be a question, but absolutely if this, happens for weeks on end or it continues to happen, then yeah, I think we're in that territory. Absolutely. Okay. All right, Romy, let's talk about Ben and Laura.
Ben likes Laura.
Hang on a second. There you go.
Oh, perfect. So Ben likes Laura. He often compliments her, invites her out for dinner, tells her that they would be a great couple. He even brought flowers on Valentine's Day. He's determined to make Laura his girlfriend.
All right, so what do we think about Ben? I've had a few Bens in my career on workplace harassment instances myself, not me personally, but for clients.
Sometimes the poll puts up some other, like a question from I think something else, but someone in the chat said yes.
Yeah. So I've got a yes. So a couple of things to unpack in this scenario. We don't really know from the facts that Romy read out whether or not Laura's uncomfortable. That's one thing we're not really sure. She might be totally pumped about getting flowers for Valentine's Day or, being the apple of Ben's eye. So we don't know how she feels. Obviously, she asks him to stop. Or if he's too intrusive or too persistent, then we're getting into harassment territory. But as I said, it's also possible that she's happy with his advances and she, maybe she's totally okay with going to dinner in that case. Maybe it's a policy on workplace relationships that comes into play. So this one for sure could constitute harassment. And it's interesting because I often raise an example that I had where I had a client with a Ben and a Laura, and Ben had no idea, I'm using their obviously pseudonyms, but Ben had no idea that Laura was completely freaked out by these advances. And he actually ended up getting the nickname in the office as Creepy Ben. But he had no idea because other people would observe his interactions with Laura, and she was uncomfortable, but not uncomfortable to say anything, but it made everybody else uncomfortable. And so it all blew up when Ben learned inadvertently that they actually called him Creepy Ben, and we ended up having an investigation and all of that good stuff. So there are Ben and Laura situations that happen. Okay, so we're going to move into another type of scenario setting. If you could turn the slide, Gloria, for me.
This one?
Yeah. So this is a different type of a poll setup. So you're going to vote A, B, C, D, or E, and the first one is you're part of an email chain in which inappropriate racist or sexist jokes are exchanged. You find them offensive and inappropriate. Have you been harassed? And if so, what should you do? So it's a two-parter, and the responses in the poll give you some options to think about. So let's see what folks think. So you just text A, B, C, D, or E. So these are where I talk about getting into a bit of a gray area. They're intended to be a bit gray.
It's not showing up in the poll for me, so I'll look at the chat and the Q&A to see.
Okay, so it may be lagging.
I think it's showing a poll from I think another presentation.
Oh, that's weird. Okay, so let's just talk about it then. So it's certainly possible. If you're part of an email chain, it says in the fact scenario, you're uncomfortable, you're offended. We know that harassment in its definition is conduct that is unwelcome. So clearly in this fact scenario, it is unwelcome. And then it talks about what should you do. So, if you've been trained under your workplace harassment policies, so forth and so on, then, maybe you send an email back and tell the individual that you're just not comfortable with the content of their emails. That's a way in which ideally it would be dealt with. But certainly, reporting it to a supervisor could also be a way to go about it. If it's something that's offensive, and particularly if it's if every day this person sends out a string of emails or, with these kinds of jokes in it, that it becomes repeated and it's offensive. So it could absolutely be harassment, especially if you're offended. And the appropriate steps would be to bring it to their attention. And if you're not comfortable doing that, bringing it to the attention of a supervisor. Okay. Romy. Oh, was this me? Or yeah.
Yes, and sorry again for the music is back on. I'm sharing the Honduran atmosphere with all of you. So next situation. Cindy and Bobby worked together. Cindy gave Bobby her personal cell number because he came to her house on the weekend to pick up a couch he had bought from her. Since giving him her number, Bobby sends the text messages commenting on how she looks every day and that he would like to go out with her. Cindy sometimes receives these text messages at work, but they mostly occur in the evenings and on the weekends. It makes Cindy uncomfortable.
Okay, so if you can flip to the poll. So do Bobby's text messages to Cindy constitute sexual harassment? What do folks think? Clearly harassment. Cindy should denounce Bobby immediately. Yeah, so I mean, even if Bobby doesn't know, like maybe Cindy's not texting him back, even if Bobby doesn't know that they're not welcome, she clearly finds them offensive. We know that from the fact scenario. And even if the majority of texts, which I think is critical here because I think this happens a lot, are sent outside of work hours and perhaps on personal cell phones, they're coworkers. Cindy's now really uncomfortable around Bobby. So yeah, I mean, I think people are saying C, D, and E. Yeah, I mean, absolutely. And Cindy should, if she feels comfortable doing so, let Bobby know that these things make her uncomfortable. Okay, so we're running short on time, so we'll do one more and then we'll open it up for general questions. And just so you know, there's additional scenarios in the manual that you can all go through and think through, and my contact information is at the end. So if there's ever any situation you want to discuss, I'm always happy to take the time to do that. So last one for the road, we've got Jill, who shares an office with Bernadette, and several times during the day, Bernadette gets threatening phone calls from her boyfriend. Bernadette shared a voicemail with Jill where her boyfriend threatened to come to the office if she didn't come home that evening. Bernadette says she's embarrassed and doesn't want anyone to know about these phone calls, but Jill's concerned about what might happen if Bernadette's boyfriend showed up. So what should Jill do? There we go. So what do we think Jill should do? And this is more of a harassment, but also potentially workplace violence, right? Yeah. So even though Bernadette is asking Jill not to say anything, and we don't know what Jill, we know they're coworkers, but we don't know if there's supervisor-employee kind of a relationship, but we know they work together. So it could be twofold. So one, in the scenario, Jill's concerned about Bernadette particularly, not necessarily concerned about herself or anybody else, but it has come up that he might come to the workplace. So yeah, I mean, I think we are definitely in, the red flag territory, as I call it. And even if Jill has been asked by Bernadette not to report, she should either, potentially tell Bernadette that, she thinks that the employer should know about it, or do it herself, so that, the employer is aware that there may be a risk, either that harassment is occurring to Bernadette while she's at work, or that there may be a possibility or a threat of workplace violence from her boyfriend. So absolutely, I agree with your answers. But you'll see, and the point of this poll was to show that it's not necessarily obvious, and there's little subtleties that might be in there, right? So perfect. So I'm going to leave it there in terms of the scenarios. I don't want to run over time. If anybody has any questions in particular, you just,
Sorry.
yeah. If you have any questions and you want to type them into the Q&A on the WebEx, feel free, and I can answer a couple of questions now. If not, like I said, my contact information will be on the slide during the break, and feel free to send me an email, and I'm happy to discuss. Do we have any questions?
I have a question from Nalini.
Okay.
Nalini is asking, based on your experience, what are some good practices to get the employer to commit to the policy?
So, I mean, unfortunately, one of the most common ways to get the employer to adhere to the policy is, unfortunately, learning by experience. And that happens a lot. Sometimes it takes a run-in with health and safety, or it takes a harassment complaint that doesn't get handled quite the way it should, to make an employer realize just how important and how seriously this is taken, and how it should be taken, and what the obligations are under the health and safety regulations. In terms of employees who want employers to take it seriously, I think it's really important to communicate that it's an obligation. It's a legislative obligation, and they have a right to their health and safety and a right to a harassment-free workplace and a violence-free workplace. So if an employee feels that their workplace does not provide adequate protection, or if they don't have measures in place to prevent workplace harassment or to deal with it, then the employees have recourses, either maybe informally through the workplace. They talk to their manager and supervisor and say, look, we're starting to get a workplace that's maybe a little out of control or a little offside. Do we have a harassment policy? Can we put one in place? There might be some internal dialogue that could happen, but failing that, I mean, they do have mechanisms under the regulation and under the Safety Act to lodge a formal complaint, which means that the employer will be looked at by someone from health and safety. They could be ordered to put a policy in place because they are required to have one under the regulation. So, I think and like I said, even though the Safety Act and the regulation puts obligations and onus on the employer, at the end of the day, workplace harassment is everybody's responsibility. So if there's, if a worker feels that that's not being adhered to, then they can absolutely take steps legislatively to hold their employer to account.
I don't see another question from the participants, but I had a question.
Sure.
It's about which workplaces should or have a workplace policy on violence.
Yeah.
You mentioned in your previous slide and in the manual that it's places where they might reasonably expect violence.
Yeah.
But given your definition of violence and some of the examples that you see, especially sexual violence, could it, what's the level of in terms of reasonable expectation? Because arguably, any place where there's multiple people working, there could be violence, right?
Yeah, and it's an interesting question, and frankly, the way the OHSR sets out workplace violence, so it differs from jurisdiction to jurisdiction, as you can imagine. In Ontario, we have to have one, period. And you do hazard assessments as you would for any other health and safety type of an issue, and workplace violence is one of them. The OHSR has done an interesting thing by they've prescribed the type of workplaces that would fall in this category, but I think very intentionally using the word reasonably could expect violence. To me, it's a bit of a signal that really there's not really a reason why a workplace wouldn't need to have a workplace violence policy. And to me, from a practical standpoint, workplaces have to have a harassment policy, so why would you not just do both? But to go to your question, absolutely. I mean, I think it's a very, and I can tell you from in my experience, and I don't think this has been tested in Nunavut at all, but in my experience, the bar would be very low. So, it wouldn't take very much for an employee to raise an issue where a court or the ministry would find, yeah, that's a reasonable expectation. So I think choosing not to have a workplace violence policy would probably not be something I would recommend for most employers, just because I think we can fall into that expectation of that we should have one very easily. So I hope that answers your question. Yeah. Okay.
Great. Welcome back, everyone. It's 2:00 Iqaluit time. I'm delighted to welcome Priscilla Ferrazzi. And Priscilla has been part of our Access to Justice committee or efforts for a number of years. So I'm really delighted that she's be able to share with you the framework for the delivery of the community workshops. Soon after this training, we'll start turning our minds in preparing some of the community visits. And as I mentioned, we are lucky to be able to have enough funding for 3 years to be able to visit a number of communities across the territory, but also in Iqaluit. And we'll be welcoming our lawyer members. We've got law students who are very interested as well. And an IQ advisor to be able to travel to the communities and deliver some meaningful training, but also pro bono private meetings. So we're very excited about this upcoming opportunity. For the time being, as I mentioned in our promo, because of the travel restrictions, the community travels are limited to resident members, but hopefully in 2021, those restrictions will be lifted and we'll be able to welcome non-resident members as well. So with no further ado, I'd like to hand it over to Priscilla, And Priscilla, you mentioned there was a little bit of edits that we need to do in this particular document. So I would caution anyone to not start printing this document, to give us maybe a week or so. I see there's a few edits that we still need to make. And of course, we'll update the membership in due time. So there you go. Over to you, Priscilla.
Thank you. Welcome, everyone. Thank you again, Leni, for the invitation. Are you able to hear me?
Yes. Yes, we are, Priscilla.
Okay, thank you. Thank you. So this afternoon, I'm going to talk about the Community Workshop Program. And this program is relevant to those of you who are going to go to Nunavut communities as part of the Prevention of Harassment and Violence project. So the program itself is based on a framework that has been peer-reviewed and published. It's a framework that explores Inuit and Western ways of knowing, sharing, and learning together. And that framework was published by the University of Alberta in conjunction with the Akimavik Society in Arviat, and it was used initially in the context of research training in Nunavut. And that framework is now being used as the basis for this collaboration between the Law Society of Nunavut and Nunavut communities in mounting the Community Workshop Program that relates to creating a healthy workplace. So what this framework does is that it brings together an Inuit education framework, which you'll see at Table 1 at page 8 of the program. It brings that together with another framework called the Revised Bloom's Taxonomy of Learning. And that's also at page 8. There needs to be a few edits there, but essentially the marrying of these two frameworks is done for the purpose of essentially sort of facilitating collaborative learning. And I'm just going to take you to the section of the manual. So this is what it's intended to facilitate: collaborative learning, which is working together for a common purpose, inclusion of participants at various stages of learning. Those stages of learning come from the Inuit education framework at page 8, and essentially we're trying to include all learners in this workshop, from those who are emergent learners, which is largely individuals who are observing and listening, to those who are more proficient learners, so individuals who are interpreting the information that you are sharing. It's also intended to provide a holistic and accessible approach to knowledge and learning. So that means that the program is intended to speak to different knowledge levels. So for example, factual, conceptual, and procedural knowledge. Procedural knowledge is sort of the steps that need to be taken with respect to a particular process, such as filing a complaint. And it's also intended to engage different learning processes. So basically, you want to ensure that the material is communicated in a way that facilitates understanding, also application of the knowledge, as well as analysis. The program content addresses education needs that were identified by the community in the consultation of the fall of 2019, which Nalini referred to earlier. And that consultation involved community organizations, businesses, government, frontline workers, and elders. So what I'd like to focus on this afternoon is the goal and the objectives of the Community Workshop Program, as well as the structure of the 3 modules. So this is the structure here, the overall structure. The goal of the program is essentially to create healthy workplaces through education about sexual and other forms of harassment. And there are 3 objectives. And the first objective is to understand and share Inuit and Western ways of making healthy workplaces. The second is to provide education about the rights of workers and obligations of employers and workers with respect to sexual and other forms of harassment. And the third objective is to make people aware of legal and health supports and improve access to those supports. So these modules, this program is basically comprised of 3 modules. Each module is an hour and 15 minutes long. The first module is about Inuit and Western approaches to creating a healthy workplace. The second is about laws that address violence and harassment in the workplace. And the third is about workplace violence and harassment policies and procedures. Communities can choose one module or more than one module. In the event that they only choose one module, each module is structured so that it incorporates a summary of the core material of the others. And it's because of this sort of structure of having the main module, and then you'll see like the core of modules 2 and 3 under the first module. Because of this integration, we have broken this down so there's a primary objective which speaks to the main topic of the module. And then there's secondary objectives that speak to the objectives of the other 2 modules that are only going to be dealt with really in a summary fashion. It's possible that a community could choose 3 modules. And in that case, you would dispense with the core summary material because you're, of course, going to be dealing with all modules in their entirety. So I want to just take you to a breakdown of a module. Okay. So this is module 2, laws that address violence and harassment in the workplace. It's important that as lawyers and law students, as well as other facilitators who are helping deliver the workshop, that you keep your eye on the learning outcomes, which are clearly set out in each module. And you will see that the module has different sort of delivery formats. So there are lawyer presentations, community presentations. In other modules, there are sharing circles. There's also participant group work. And you'll find that each topic is time limited, which means that lawyers essentially have to distill key points for each topic from the Violence and Harassment in the Workplace Legal Resources Manual that Odessa was just reviewing, as well as from other materials that may be provided to you with respect to Module 1, which deals with the Inuit and Western approaches to creating a healthy workplace. You will need to take the key elements of the topics that are set out in each module under each time frame and ensure that you're able to communicate and share that information within the allotted time. Each module ends with a wrap up. There's a community reflection, which involves all participants, as well as reference to resources and supports, which are found at page 9 of the program. And then there's an evaluation, which Nadine will speak to later. But I'm just going to take you briefly to the evaluation. You'll find it in the manual, and in the event that the participant exit survey, which is what this evaluation is forgotten when you're actually flying into the community, you can always have participants complete the one that's in the program, and then you can just have it ripped out and carry it back with you because the Law Society is keeping statistics on these programs. So the purpose of the community workshop program really is to provide a roadmap for all individuals who are involved in the actual delivery. So that's the lawyers, facilitators, law students, as well as community members. And it is to facilitate basically an interactive kind of dynamic between the Law Society and communities. It's intended to foster collaboration in order to achieve the overall goal of the community workshop, which is to create a healthy workplace through education about sexual and other forms of harassment. So that's just a very brief overview of what the community workshop program looks like. It is pretty fast-paced, and we grappled a bit with respect to the length of the modules, but in order to make them as accessible as possible, we limited the modules to 1 hour and 15 minutes. So the community does all three. Of course, it's 3 hours and 45 minutes, but 1 hour and 15 minutes, means that you're packing in a lot of information and engaging in interactive exercises as well as dialogue within a time frame that you really need to keep your eye on. But I hope that this will help lawyers and others, make it through these modules in a way that's coherent and informative for the community. Happy to take any questions. Yeah, I see a question about the time allocation. Yeah, why is the time allocation so tight? It is tight. It's possible that you can negotiate with a community for a longer period, but in the absence of any, in the absence of the latitude to have more time, we stuck to 1 hour and 15 minutes in order to make it accessible to people after work. Students, whomever it is that are going to participate. We thought 1 hour would be reasonable. It does require that lawyers really put their minds to summarizing key points in the delivery of the topics that are set out. It is somewhat of a limitation, but it's not a limitation that needs to remain if the community is prepared to participate for a longer period of time. 1 hour and a half, 2 hours, whatever it might be.
And I can jump into that just to give a bit more context. It's because we want to make sure we're meeting the needs of the community. We're creating a working group for each of the community before we would travel to the community to have a really good opportunity to understand their needs. So if the community chooses 1 or 2 modules and they'll have the time to extend the workshop, and of course the lawyer with the rest of the team can make themselves available. We're just mindful that sometimes there's a time constraint and we want to be able to deliver on the key points within an hour 15. Again, if the community is open to welcoming the team for a longer period, we will of course be able to deliver on that. Any more questions? Anyways, most of you know how to find me or find the Law Society, so don't hesitate to send an email out. We'll keep the membership apprised as we start planning for our community visits. And thank you, Priscilla, again for taking the time for sharing the overview of the program. And we will provide an updated version because we have a minor tweak to do. Great.
Thank you.
Thanks, Priscilla.
Thank you.
I will welcome Nadine very shortly. So part of undertaking these important, we want to make sure we have standards, we've got a strong foundation, all of which to deliver on meeting the needs of the communities on this very important topic. We want to be able to empower both employees, employers of creating healthy workplaces as Adessa mentioned sometimes employers will kind of learn on the fly of what their obligation is. So we're hoping that after 3 years, more Nunavumi will be have a better understanding of their rights, roles, and responsibilities. And part of that, to ensure we're able to meet those goals, is we've reached out to Lichen Consulting, which is based in Iqaluit, and Nadine is joining us from Ottawa today, but Nadine has developed such a meaningful, relevant evaluation tool framework. And today she's going to give you an overview of the tools that are relevant to the community visits. So Nadine, are you hearing me?
I am, yeah. Can you hear me okay,
Okay,
Nalini?
wonderful. Yes, so I will stop the video and I will turn it over to you. Oh, there we are. Nice to see you.
You too.
Good. Go ahead.
Well, thanks everyone for having me today, and thank you for gathering on a Friday. I think this is really important work that the Law Society is doing, and I'm so pleased to be a part of it. So as Nalini mentioned, I'm just going to take you through some of the data tools that have been put together to kind of catalog the work that's being done in the project. And I'm sure I don't have to stress to this group the importance of compiling data and keeping track of what we're doing and logging the work that is done. You'll become familiar with these tools throughout the course of your work on this project. So please, if there are any questions, let me know. They're very straightforward, but if there are any questions, please do let me know. And if you have problems later on, I am always available through Nalini as well. Okay, so Gloria, if you wouldn't mind to, thank you. So the tools for project monitoring and evaluation for this project there are multiple tools. Now, the ones that are going to be important for this group here are the first three. If you wouldn't mind, Gloria, the next slide. It's the event facilitator log, the lawyer log, and then the participant exit survey, which we'll discuss a little bit later. So the key tools to begin with, the event facilitator log. Now that log is for anyone who is doing any of the plea sessions in the community or workshops in the community. Next slide, Gloria. Thanks. So this event facilitator log, it aids in documenting the process of delivering the public legal education and information sessions, as well as the uptake and quality of those sessions. Thanks. Any subsequent face-to-face legal consultation should also be recorded here. And when we're talking about subsequent face-to-face legal consultation, that is any consultation that would take place directly after a public legal education and information workshop or session in a community. So any of those face-to-face sessions that would happen directly after a workshop. This information is going to be really crucial for the Law Society to understand and monitor and evaluate the progress of the project. And some of it is also going to be used for mandatory reporting purposes. If you can go to the next slide, Gloria, it just shows this log a little bit bigger. So the event facilitator's log is extremely straightforward. You can see at the top, you've got your community name, the date that you're in the community. There's facilitator and co-facilitator information at the top, and I've just written whether or not information is required or optional, and you'll see that the facilitator and co-facilitator information is required. So the facilitator would be the lawyer or other party who is running the workshop. Co-facilitator, there may be co-facilitators in some communities. I think in some sessions there may not be. And then it's really just circling yes or no. So this facilitator has received and reviewed information about the principles of trauma-informed practice. Yes or no. Facilitator has received and reviewed information regarding IQ and Inuit societal values. Yes or no. And the facilitator has received and reviewed information regarding cultural safety and cultural competence. Yes or no. So that's for the facilitator and co-facilitator. Those are important for us to understand the type of facilitation that we're doing, the type of preparation, I should say, that the facilitators have had prior to going into communities. It's one of our quality markers to understand the quality of facilitation. The next section is event information. So this is really specific to the community that you're in. So is it a community-based plea session, employer-based session, an academic lecture, or something else? So in this example here, I've put employer-based, and that the employer is the town of Kingate. So if Kingate was requesting, if the town of Kingate was requesting that we were to go in and do a session with town employees, that would be the employer-based session. Total number of participants, fairly self-explanatory. And then number 5 is the materials distributed during the event. So you can just circle the type of material that's distributed. So whether it's the workshop program posters, resource sheets, etc. And then the approximate number. So we're doing approximations here for hard copy materials that are distributed. The project manager and coordinators will keep track of things like listening audience for radios and webinars. But for hard copy materials that are distributed during events, we'll just get you to circle one of the approximate responses, so we have an idea of kind of what we're delivering. Next slide, Gloria. And then the next bit is the narrative and notes. This is optional, so it's not necessary to fill in. It's really, if you've got something to say, please do record it here. This way Nalini won't have to be chasing up 6 months later to find out a little bit about your thoughts about the workshop. So were there any challenges or lessons learned during this event? I've put an example here that the workshop was scheduled outside of working hours, which limited some attendance. So this can be just your thoughts or observations about how the workshop went. Was it well attended? Was it not well attended? Did you have any commentary from the participants about things that could be improved, or anything that went really well? As I said, number 7, participants expressed appreciation of the inclusion of a local interpreter and elder. 8 also is optional. Were there any unanticipated or unplanned themes or topics brought forth? Now this we've added because in the community session, the pilot session that was delivered last fall, it was really interesting that we had some very interesting topics on related to employment in Nunavut, but not specific necessarily to harassment, although sometimes interconnected. So we did want to be able to capture the key priority areas that are being brought forth by community members and employees. So in this example, I've just put participants wanted to discuss labor laws in Canada, specifically in relation to leave allowances. The discussion evolved to include discussion about leave entitlement to participate in on-the-land activities such as hunting and fishing. It wouldn't be unusual, I think, to have participants, requesting this type of information from you during sessions. Now, that's not necessarily what the plea sessions are going to be covering, but it is important for us, I think, to understand what the other employment priorities are for communities as well. And then the last bit on the event facilitator log is a table, and this is for the in-person, face-to-face legal advice that's given immediately post-event. So I've filled this in as an example. Column A was legal advice given, yes or no? Was the client that you've given legal advice to a referral in, so referred to you from someone else? Or was it someone that you referred out? So if you refer out to other legal services, that's, I think, fairly self-explanatory. Sometimes you might find that you would need to refer out to another source, such as requesting that they go to income support, to social services, to a health center. And there we ask just that you record a little note of where you've referred them to. Gender and age ranges might be estimates. Gender is male, female, other, or people prefer not to say. And I think it's fairly easy to tell. The line 7 is where you've just got the total numbers, and that's really all that needs to be recorded for the event facilitator log. So the next one is the lawyer's log, and that is for anyone who's going to be providing legal advice outside of the community sessions. So this aids us in documenting the delivery of the legal advice that's given throughout the project. Next. Thanks. So this information, again, is going to be crucial for the monitoring and evaluation of the project, and some of it also will be used for reporting, mandatory reporting purposes. It provides some demographic information about those who are accessing the legal advice, and also captures some information about the referral partnerships and pathways that are being created by the Law Society through this project. Next slide. So again, I've just got a sample here that I've filled in. So at the top, you'd put your own name, the date range of the timing of the log. The first section there, columns A through D, are the type of contact. So you can just put an X or tick mark or whatever you choose for whether it's by email, phone, in person, or other. I'm not sure what the other would be, although I guess someone could send a letter by post or something. So the numbers in the first column down the side, 1, 2, 3, 4, are simply the number, the client number. This doesn't have to be traced back to any particular client. It is simply a log. So we're not concerned with, you know, what the number actually is. It's just to keep track of the quantity. Columns E through G are, again, that referral in and referrals out. So that same thing applies as to the referrals in and out for the public legal education and information sessions. If it's referred in to you by someone else, if they tell you that such and such a legal service has requested that they contact you for this information, that would be a referral in. Referrals out for other legal services would go under column F. Column G, again, is other services that are non-legal services. Location of the client, we've split it into regions. So Iqaluit, Cape Dorset, Clyde River are in the first region, Arviat and Rankin in the second, and Cambridge Bay is in the third region. Any other would be people coming from other communities in Nunavut or outside of Nunavut. I know that there are other Nunavut communities that would fall into these regions, but those are not necessarily communities where we'll have a specific focus for the project, so we're going to consider them other. And gender and age, I think, again, are fairly self-explanatory. So that is it for the lawyer log. You can subtotal at the bottom. Line 21 and line 22 is just your totals throughout. Okay, thanks, Gloria. And then the participant exit survey. I left this, I did include it here because it will be important that you know about it in order to hand it out, but it's not something that you have to have a whole, you don't have much responsibility for. So the participant exit survey is exactly what it sounds like. It's something that's given to participants at the end of the public legal education and information workshops. And it's, again, just a method for us to be able to understand a little bit about whether or not we are meeting the needs of the people who are participating in the workshops, and something about the quality of the workshops that are being delivered as well. If you wouldn't mind to go to the next slide, Gloria. Yeah, so it captures some demographic data and gives us a session evaluation from the participant's perspective. So the information that would be important for the lawyers to be able to record for us in the top left-hand corner. Sorry, you can go to the next slide, Gloria. Yeah, sorry. It's the top left-hand corner, top right-hand corner of the administrative data. And the only thing that you would be required to do is check off whether or not the event was a community, employer, or academic event. The rest is left up to the participants to fill in whatever information that they choose. So we would expect that the facilitators of those sessions would pass out these surveys at the end of the session and then collect them as well. And I think that's it for me. So I am absolutely available for questions. Please do let me know. I see that Rachel posed a question, I think shortly after Priscilla's session, that said, can we talk a bit about target audience? I'm not sure if that was covered already or what exactly that was in reference to.
I was going to speak to it in my closing remarks. Yes. Does anybody, before I do that though, does anybody have any questions for Nadine on the logs, or general questions over overall on the evaluation itself? It's a lot of information to take, but it's just as I mentioned, when we put together the working groups for each community visits, we will have an opportunity to review those tools to make sure everybody has a solid understanding. But we wanted to take a moment with Nadine today to just give you a broad stroke of those tools. So I wanted to thank Nadine for sharing her profound knowledge and expertise on evaluation. It's been a learning curve for me, so I'm so thankful she's been part of this journey, because it is a mandatory. A lot of the data is part of the mandatory reporting for the Government of Canada. So with some really good tools in place, it'll make my life much easier. So thank you, Nadine, for taking the time on this Friday afternoon.
Nalini, I think we do have some questions.
Oh, for sure. I'm all ears.
Sorry. It's in the chat. I don't know, Nalini, can you see, or Nadine, are you able to see the chat from Rachel, the question?
I am, yeah, and I'm just typing a response, but I think I'll maybe just respond verbally to you, Rachel, if that's better. So for the plea sessions, I think your question is in reference to where that administrative data question is at the top right-hand corner. And the plea sessions will almost always be requested either by the community, by an employer within the community, or other, such as an academic institution. So when we're talking about employer-based plea session, that's something requested by any employer, or if it's community-based, as in like the community has just requested for us to come in and speak generally to multiple employees from different organizations, that would be community-based. So if there is a community where both a specific employer, such as the town, for example, and has asked us to come in and speak specifically to the employees of the town, but have also requested that we have open sessions to the rest of the community, then yes, I would absolutely say you would check off that it's both community and employer based.
And if I can add to that, the team is also developing a number of public legal education information tools, and one of it is targeting employers. We're creating a toolkit for employers and a toolkit also for service providers. So we want to be able, again, to meet the needs of the community itself. So hopefully that answers your question, Rachel. Any other questions, Gloria? I don't think did I miss any other questions in the chat room? I just want to make sure before I close off our for the day. Okay, I think I've seen the questions. Well, I wanted to thank again this designated team. I couldn't be able to reach this point today without the support of all of the speakers, and with Gloria and Romi's support. 1 year into to reaching this point today and providing the training. So hopefully you learned. You're empowered to find a way to share the information you've gained today with as many people as possible, as harassment-free workplace is such an important notion that we want everyone to be able to benefit from. And then hopefully, as I mentioned, it empowers employers, employees of having a better understanding of their rights, their roles, responsibility, and taking a step to voice if they're going through a difficult situation. And why I speak like that is because I see it coming through our Law Society's doors, regularly of members of the public looking for referrals are really struggling in finding the best way to address a difficult situation or uncomfortable situation that they're going through at work. So I see it firsthand right here in our office in Iqaluit. So on that note, I wanted to thank everyone for taking the time on this afternoon. And remember that all of the tools that are on our website, if there's going to be an updated version, like the community workshop program, I will definitely send a note to the membership to advise you that there's an updated version. So I would just hold on doing any printing at this moment until we're there. And we very much look forward to keeping the membership and Friends of the Law Society, including our law student, many of whom have joined us today, of keeping you updated as we move forward with this important project. So thank you, everyone, and a special thank you to our to Odessa and Jason from BLG for helping the Law Society deliver its first virtual training today. So thank you. Have a lovely weekend, everyone, and definitely let's keep in touch. Bye-bye.